Imagine this. You've lost your case in the court below, but now the U.S. Supreme Court has agreed to weigh in. Okay, don't yell so quickly. A coin flip could still ruin your Supreme Court fun. Here's how. The Supreme Court regularly grants multiple cases presenting the same issue. It happened in last term's same-sex marriage cases, where the court granted and consolidated 4 cases. That's how a poetic civil rights opinion by Justice Kennedy got stuck with a jarring name like Oberga or Overage or whatever. Not just 4, but 7 cases were recently pending at the High Court over the application of Obamacare's controversial contraceptive mandate to religious nonprofits, like this group of Catholic nuns. And with an emblematic circuit split on the issue, many court watchers expected the court to grant 1, maybe 2 cases. But all 7? Of course, granting so many cases at once has its pros and cons. One pro is finality. The court can address nuances in different scenarios at the same time. But one big con is frugality. Frugality in oral argument time, that is. The court typically only allows 1, maybe 2 attorneys to argue for each side. So the 7 petitioners here must winnow their arguing attorneys down quite a bit. And the Supreme Court's clerk's office isn't afraid to get involved if necessary. The clerk famously flipped a coin in a 1997 case, resulting in the less experienced attorney arguing and, of course, losing the case. And according to a recent news article, parties have recently done the same without the intervention of the clerk's office. But the parties in this Obamacare case seem to have sidestepped the dreaded coin flip. After a joint motion, 2 Supreme Court veterans will argue for the parties challenging the Obamacare requirements on March 23rd. And with the U.S. Solicitor General likely arguing as well, this case is set to have all the drama of, well, I guess a decisive coin flip.